Friends, welcome to the 278th session of Legal Empowerment through Interaction lecture series. Today, we are on a topic which is in fact the interface of law and technology. We had classes and lectures on what exactly are the requirements for protection of electronic evidence in court, legal requirements, etc. But till date, we did not have any in-depth discussion on the technology behind it, or how the digital evidence or electronic evidence is to be identified, it is to be procured, preserved, analyzed, and presented in a court of law. Today, we are confining ourselves to those aspects. I mean, we are dealing with the men behind the scene and also the technology behind, because we are only on the surface, wherein we know the legal thing. We have discussed in detail about the requirement of Section 65B certification, etc., etc. Today, let us look into the technology. To speak on the topic, we have one of the best speakers around. He is a much wanted cyber forensic expert. He has been sought out as an expert witness, analyzing, etc. He is Sri Nabeel Koya. He is attached to C-DAC, the Center for Advanced Computing, Thiruvananthapuram. And to introduce the subject, we have Advocate Dr. Sushanth, a good friend of mine, and a techno-legal consultant, a cyber law expert. He has been recently recognized as one among the top 100 in 2022 influential Indians for his contribution to cyber law and the web-enabled technology law related to that. And to render the concluding remarks, we have another good friend who had occasion to address on this platform, Bhadran sir. He was a former scientist of C-DAC. We had occasion wherein he was an expert witness in a couple of my matters, wherein that was in the initial stage when nobody knew what hashing was or what exactly the digital evidence was. And somebody even thought that digital signature was drawing signature using the mouse. At that point of time, our interaction goes back to that period. Today, we are also privileged with the presence of Justice Ramakrishnan sir and all of you wonderful participants who have been part and parcel of this wonderful journey of empowerment, enlightenment, and discussion on different topics. So without wasting any time on the topic, let me request Advocate Dr. Sushanth to render the introductory remarks. Sushanth, please.
Thank you very much, sir, for this opportunity. Very good evening to all the participants, and Letil is again doing a fantastic job. And I must really say that it is connected almost everybody across the globe. So just like internet makes geography a history. So I believe this is very much true in the present case of Letils. So thank you very much, sir. I think digital evidence is something that is now gained more and more popularity. And I really think that everyone, earlier, when we looked at, digital evidence, I think 1 out of every 5 matters was relating to digital evidence. But in today's context, I believe almost 8 out of every 10 cases involves the component of digital evidence. So therefore, whatever evidence we have today, whether it's a computer printout, it's ultimately a computer output as well. So therefore, digital evidence plays a very, very critical role in almost all cases today that are presently there, whatever be the subject. So in this context, I thought I just quote 3 of the very interesting cases where digital evidence was sought from different and untraditional devices altogether. So there is this very interesting case which happened in California, where evidence was sought from an IoT device, which is Internet of Things enabled device, which is a smartwatch. Today, a lot of us are using smartwatches where we are connecting our mobile phones, especially where we're actively using it for both professional as well as personal purposes. And in this case, it was absolutely a different matter altogether, because people realized that the Internet of Things enabled device could be used as an evidence to solve one of the very good mystery cases which happened in California, where a 90-year-old suspect was able to get caught, because of simple evidence that could be captured from this internet enabled smartwatch that was present at the crime scene. So I think this is another example to showcase that the traditional ways of collecting digital evidence versus the current way of collecting digital evidence has entirely become a new phase altogether, especially after COVID-19, where almost everybody has joined the digital bandwagon, and we're using digital in a much more better and in a different manner altogether rather than what it was prior to COVID. So I thought I'll just give you this information so that that will also be another source of digital evidence. And one last thing I would like to conclude. Today, everybody are using mobiles. I think mobiles have become center to our lives. And for those of us who are using mobiles today, whatever information that we are relying as digital evidence from the mobile, whether it's a communication related evidence, or whether it's a photograph or a video, or whether it's an audio, I think all of these are getting stored on a cloud. So which is entirely different and which was never this popular, earlier. So I believe that cloud has now become the most interesting element as far as digital evidence is concerned, because extracting information from devices was known, but extracting evidence from cloud is something that is now becoming more and more popular, especially with the increase in the mobile related crimes and also usage of mobile phone by all stakeholders. So for those of us who are using a mobile phone, automatically, if you are using a normal Android phone, you have all the data synced to your Android cloud. For those of you who are using Apple phones, maybe iPads or iPhones, all this information gets stored on your iCloud. So extracting evidence from iCloud is also one another interesting element altogether, and more so in the context of what's happening currently. So I think digital evidence is something that really requires a lot of understanding. And I think we have a very interesting speaker who has a wide range of experience in this domain, and he's also been an expert witness in few cases. So I believe that this is going to be a very interesting session, and I'm really looking forward for knowing much more into this area. Over to you, Shyam sir. Thank you so much.
Thank you, Sushant. That was Sushant all the way from Hyderabad. Thank you very much. So the stage is all set for Nabeel. Please.
Thank you, sir. I'll just share my screen.
Sure.
Good evening, all participants. Myself, Nabeel from C-DAC, Trivandrum Center. So what I would like to cover in this next 45 minutes or 1 hour, 60 minutes is about digital forensics, the technical part. I would try to make it in a way which is understandable to the legal professionals who are attending this webinar. Is it right, sir? Can you see the screen?
Yes.
Okay.
Yes.
So the agenda for the day will be, we'll start with digital forensics. What are the different types of digital forensics, the procedures involved, and the standard operating procedures. So as practicing legal professionals, almost all of you know what is a cybercrime. So this is a definition which I have taken from Wikipedia. It indicates that any crime that involves a computer and a network. And the computer might have been used in the commission of the crime, or it might be the target. So it can either be a source or a target. Source is you use a phone to stalk someone, or target might be you disrupt somebody's computer which was working properly. And there are different types of cyber crimes. This is just an indicative list. Theft, you can identity theft, data theft, and device theft. Device theft is theft of mobile phones. Data theft is which usually occurs. I go to an office, plug in the pen drive and take the data out of the computer without the consent of the concerned authority. Identity theft is which we usually see in social media networkings, where you create a fake profile and try to generate some information and try to spoof persons actually. Cyber stalking is there, phishing is there, computer piracy, because now lots of startups are coming into the country. Now what happens is, all of a sudden, few of the members leave the company, they start a new company, with all the source codes, all the IP intellectual rights which they had initially the company had generated. So it causes a big loss to the company. Then economic offenses, basically these online lottery schemes, which is a money laundering scheme. And there's a beautiful word which has been defined for people who are middlemen in this activity, economic frauds. So it's known as a cyber mules. It has been coined by Rose Anderson of the Cambridge University. He has written a book called Security Engineering, in which he mentions such people as cyber mules, because in most of the cases in online frauds, the investigation ends at a point where there are people who had been transferring the money, but they don't know whom they are working for or to whom the to which company they do allegiance to. Then also defacement, which is a very rampant in social media networks nowadays. So these are some of the crimes to be listed out. So for any crime, there should be a procedure laws to combat cyber crimes. And India was one of the first countries to promulgate the IT Act in the year 2000. So what basically IT Act is all about, it is the usage of digital signatures and electronic communication transactions. This means that I can send a letter over an email to the police station, and he is bound to give me a reply within the next 24 hours. So, but the act was passed in the year 2000, but that time the infrastructure of the computer that was available is, for those who can just recollect, is the network speed was, the internet speed was 28 kbps or 56 kbps. The computer was coming as a price of 75,000 rupees a Pentium machine, and it was not a normal available resource to conduct such cyber crimes. But after 2005-2006, when smartphones came into the market and new technologies also came into the market, the growth was very unimaginable way of digital explosion happened. So the number of cyber crimes also started increasing. So recalling Shyam in the initial remarks, in the initial days, 2004, 2005, it was all petty crimes actually. A single computer where fraudulent currencies were made, certificates were made. But 2010, you can see the rapid change in which the criminal activities were happening. And as Sushanth sir was also mentioning, right now, if you look at it, 2020, 2021, 22, most of the activities are happening on the cloud systems. Now, any judiciary works on the evidentiary data. So anything, whenever a cybercrime has happened, you need to identify the proper digital evidence. And the evidence should be tamper-proof in a legal context. So these are some of the properties of any general evidence. It should be admissible in the court, it should be authentic, it should be reliable, believable, and it should be complete. So this is the first definition of the digital forensics. So if you can see here, the definition was coined in the year 2001. And Digital Forensics Research Workshop is an annual workshop which is held every year, which addresses to the new challenges, or you can call the hackathons type of thing, where new challenges are introduced and people are welcome to come up with solutions to how to combat such situations. So this is a big definition. So I'll just read it out for you. The use of scientifically derived and proven methods towards the preservation, collection, validation, identification, analysis, interpretation, documentation, and presentation of digital evidence derived from digital sources for the purpose of facilitation or furthering the reconstruction of events found to be criminal or helping to anticipate unauthorized action shown to be disruptive of planned operations. This is a big definition, but the crux of this definition is you need to preserve it, you need to collect it, you need to validate it, identify, analyze, interpret, document, and present it. So that's the crux of this definition. So we will see what are these different steps in the coming slides. So this is the base root of any forensics principle, Locard's principle. So Edmund Locard is a French scientist who stated that every contact by a criminal leaves behind a trace. So the same principle applies to digital forensics also. So I'll just show you an example here. So most of us do this activity. We put a pen drive into the computer. So have you ever noticed that whenever you introduce a pen drive into the computer, you see something like that, a mass storage device has been connected or something like that. So it takes a couple of seconds to ensure that the pen drive is shown in your My Computer or My PC. So what basically happens is there is a handshaking happening between the pen drive and the computer. That means some data is written to ensure that the computer wants to identify that this is a pen drive, or it's a memory card, is a SD card, or some other device. So this is what basically happens. So that means whatever activity you do on a computer, there are some traces left behind. So now the forensic part will be to find out what are those traces and that put it in a legally admissible format. So the cardinal rules in digital forensics is you should never work on the suspect device. And the reason being, if you look into other forensic sciences, you are always working on a sample of the original evidence for the blood stain or a hair fingerprints or anything you look into. You're just working on the samples of the original, which will be equivalent to the analysis of the complete original evidence. But in digital evidence, you cannot work on the original evidence. You need to work on the copy of the original evidence. The reason being the same factor which was shown here. Whenever you do something when you're putting a pen drive into a computer, suppose the pen drive was a suspect device, there was some data transfer happening between the computer and the pen drive. That means there was some tampering happening on the device. So that's the reason why you should never work on the suspect device. And use a write protection mechanism while connecting the suspect media. Again, taking this device, if you are directly connecting the pen drive to the laptop, that means there is something happening between the pen drive and the computer. But if you equip a device in between, which stations in between the pen drive and the computer, that will ensure that nothing is going into the pen drive and only it will give out the data. It will not write any data. That means your evidence is protected. So the challenges in digital evidence are it's volatile, fragile, and can be tampered easily. And there's a lot of hue and cry about this tampering part in most of this media recently. So the reason being, it can be crushed down. It can be the moment I see a police, I can put it down. I can throw it out of the window. So it's very easily destructible. So how we can do this analysis is a big challenge, and then hence the reason a new set of digital evidence rules are there compared to other forensic sciences. Now, let's come to the technological part. So what are you going to analyze in a digital evidence? You're looking into the data storage mediums, actually. So that's where your data is going to be stored. So digital forensics involves the examination of two types of storage. Basically, it's a volatile and a non-volatile. So to give an example, volatile data is your RAM of your computer. Whenever you shut down the computer, or unexpectedly your power goes down, all the work that you have been running, all the drafting you have been running, or the banking transaction you have been doing, that goes off, because it is the memory, it's the area on which your currently working data are running. And that goes as soon as the power is brought on. And you can see here in the figure downstairs, these are the RAM actually, where it doesn't have a provision to store the data once the supply goes off. And the second one is a persistent data. Persistent data, even if the power supply goes down, your data can be retained. That's where you use your pen drive, your memory card, your storage media, your hard disk. So the hard disk is a typical example of a persistent data. Now, these are the containers for storing your data, and data is stored in the digital evidence. And whenever you get a digital evidence, you need to analyze these data. So digital evidence can be a hard disk, it can be a pen drive, it can be a mobile phone, it can be server systems, and so forth. And if you can see here a diagram which I've shown, this is the internal memory of a mobile phone, what you call the internal memory, or the system on a chip of a mobile phone. So this is a hard disk, this is a pen drive. The reason being, in a mobile phone, you cannot detach your storage media from your motherboard or your chip. It's embedded into the system. So that makes digital evidence different for devices like mobile phones. So that is a difficult part of digital forensics also. For each device, you need to have a different types of standards. And data can be stored in various forms. We can store the data in video, audio, text, tally, whatever type you have. And so the message is actually, you have the digital evidence which you need to analyze, and the digital evidence contains data, and data can be stored in various formats. And these form basically they're stored in the form of files. So you will have a video file, you can have an audio file, you can have a text file, you can have a tally file, you can have an Excel file, anything you have as per your application or your requirement. So again, just for a clarification, the data, as you all know, it's in the binaries, bits and ones and zeros. So if you want to understand that ones and zeros, you need to have something called the files actually. So this is how files are the containers for storing the data. And there is a terminology called metadata, which is also commonly used in the media nowadays actually. Metadata is the information about the file actually. So a typical example of a metadata is whenever you capture your phone, a camera photo on your camera, either your standalone cameras or your mobile phones, and you can just view it on a, just open it in a notepad file. You can see that the source camera, the date of creation, what was the pixel code, so many informations are available. So these are the metadata relating to the picture file. Similarly, for any file, there will be a metadata. So to make the long story short, it's actually like this. You have a storage media, and that storage media has to be in a particular format so that you can understand the data. For that, you have something called the file system. And within that file system, you store the files. And within that files, you have metadata about the files. So just to give an understanding how the data is stored internally. Now, these are the various digital evidences that you can obtain. Physical media includes hard drives, computers, mobile devices, which we have just discussed. Digital images and files are produced when digital evidence is copied from physical media. Then, as it was mentioned earlier, digital objects include a wide variety of digital material that does not exist as an image, such as an online account, the cloud, the Facebook account, and such information. And also there are digital evidences which specifically law enforcement agencies, body-worn cameras, car videos, electronic records. When a car crash happens, the information available from the car, these are all comes as a digital evidence. So these definitions of the digital evidence has been taken from NIST standards. And NIST is the National Institute of Standards and Technology under the US government. And they, in collaboration with the National Institute of Justice, they provide standards regularly for the digital forensics and the digital evidence. So digital forensics disciplines, if you look into, cyber forensics standards were initially defined for hard disk. The hardware and software industry grew leaps and bounds after this era. So new forensics procedures were introduced for the evidence. So now it has become a new science or engineering within itself, because just as you say cyber security, cyber forensics has become an independent discipline, because whatever new technology you have a counterpart of the criminal activity, and similarly you have a forensics to it. And standards are issued by NIST under the NIAJ USA. So if you look into the classification, you can see there might be other standards of classification. This is one which is available from the NIST standards. One is disk forensics. As we mentioned earlier, we have a storage media. When the power supply, even the power supply goes, you can store the data. That is a disk forensics part. The live forensics, you need to get the data in the own condition itself. You cannot switch on the machine, the data is gone forever. Network forensics, you need to get information from the servers, because a banking server or a server which is running the billing application of electricity board or water authority, you cannot shut down the computers because this business will be affected. So what are the information that you can get from the information? So there is a ransomware attack or some other type of attack. You need to understand what is information. So those come under the network forensics part. Then is the embedded forensics. As Sushanth sir was mentioning here, you have a plethora of smart devices in the market. Your mobile phones, your smart devices, your IoT devices, your GPS devices, your in-house vehicle, car in-house entertainment systems. These are all embedded devices. So these embedded devices, the internal architecture of these devices are not known, because it's a very different. Take for example, I'll just quote an example here. We had received a case in which this fishermen use GPS devices for obtaining the latitude and longitude while traveling. So in one of the cases in which the police had confiscated them, these devices were from China, but the Indian architecture could not be known. So you are not aware of how the data is stored and how to retrieve the data. So that's an important restriction, or what you call the difficulty part of an embedded forensics. And that's the reason why whenever you work on this forensics, the standards are much more known. But on the other part, the live, the network, and the embedded forensics, still research is going on and 100% solution is not available. And another classification is on the type of activity that you do. You can do the forensics in the on condition, or you can do in the off condition. Those devices which you do in the on condition are memory forensics, network forensics, live forensics, and mobile forensics. And offline is disk forensics, mobile forensics, and log forensics. You might be wondering why the mobile forensics is in the online forensics and the offline forensics. The reason being, the older generation of phones, our older Nokia phones with an antenna, or the Samsung with an antenna phones, you use switch off the mobile phone and try to extract the data. But in the new generation phones, where you have an Android, Apple, BlackBerry, Windows, and you have a system on a chip solutions, you need to do the analysis or any digital forensic activity in the on condition of the mobile phones. So this is a broad understanding of what are the different steps in digital forensics. So the first step is identification, then seizure and hashing, then you have authentication, acquisition, analysis, presentation, and preservation. So the first two steps happen at the scene of crime. The investigating officer, who is responsible for doing the investigation, he has to identify what are the digital evidences available at the scene of crime. And then he has to confiscate the evidences. Then, as per what we observe in Kerala, the case is forwarded to the forensic science laboratory. And at the forensic science laboratory, they need to ensure that the evidence hasn't been tampered with. Then they need to do the analysis. And finally, they need to present it before the court and preserve the evidence for a longer period of time. So the authentication, that is to ensuring that the evidence hasn't been tampered with when it is received from the IO, is done at the forensics laboratory. Then they make a copy of the original evidence to ensure that they work only on the copy of the evidence and never work on the original evidence. And finally, they do the analysis. So these are the 7 steps in which the forensics has been evolved. But if you look into, if you search for the standard, what are the different steps? You cannot, every time you can not find 7. Sometimes it can be 4, it can be 5. This is one of the standards which has been written by an IPS officer, the National Police Academy, way back in 2002. So he had mentioned that as per the Indian condition, this is the best suited method. So that's why I have put across this 7 steps. Sri Ashok Dohri IPS, who is currently a DGP with the Maharashtra Police, Madhya Pradesh Police. So identification, this is the most important task. All the digital evidence should be identified, and the investigating officer should not discard any device electronic in nature. Because why this statement is, because again, recollecting Shamsa's earlier introduction into cybercrime scenario, there was a scenario where we had a monitor type of devices. Bhadran and Shamsa was investigating it. They had monitor type of devices, but they were not able to find out what is the computer behind it actually. So it was a new type of devices where the computer was behind the screen, what right now we call all-in-one PC. That was not very common at that point of time. And similarly, we had a device in which we had an Android phone, but internally it was running an Apple OS. So what application do you do to image it? So these are the challenging parts from the investigative office. They need to identify what is the exact evidence, or there are your ball pen type of pen drives. You need to take out those evidences, and they also need to ensure a chain of custody format. Now, seizure is the process of capturing suspect computer for evidence collection and generating hash file. Now comes a seizure principle for hard disk. As I mentioned earlier, digital forensics, there are different standards for each type of evidences. For a disk, you have a standard. For the mobile, you have a standard. For the memory, you have a standard. For the network, you have a standard. So I am just mentioning here about it. for a hard disk. So the moment the investigator goes to the scene, he sees that the computer is in the on condition. What he can potentially do is, if he has the exact tools with him, he can just go do a live forensic. That means he can see what are the activities running on the machine, to whom it was communicating, what was the recent emails that has been sent, so what was the pen drive that has been inserted, so information can be obtained. So a typical scenario in which this is going to the scene, it is in the on condition, will be basically when they are going to raid an office or investigate a big business houses, where we can see, if you go to any big shops like the supermarkets, you can see that the machine, the cashier's counter is a dumb machine. It doesn't have much information. He just scans the data, the offers for the day comes into the billing system, and the bill is finally delivered. So those analysis the live forensics analysis will help to identify what was the state of the machine and what was running on the machine at that point of time. And once that has been done, he will shut down the machine, and then he will do a process which is known as a hashing process. So what he does is, he removes the hard disk. Suppose this is the suspect hard disk. Now he introduces a device which is known as a write block in between the suspect medium and the device. And the other end is connected to a computing device, which is a laptop or something. So what basically it does is, the laptop will have an application which will calculate the hash value of this hard disk. And it will also, the black device sitting in between will ensure that nothing goes into the hard disk, and the investigator can be safe and secure that he didn't tamper with the evidence at any point of time. So this is how a write blocking looks. So you have the suspect hard disk here, you have a write blocking device connected in between, and then you is connected to a laptop. So the laptop will have an application which will identify this hard disk and do some computation, and finally you get a hash value. So the write blocker is to ensure that the data isn't being, any data within the device is not tampered with. So coming to the hashing. So hashing is a mathematical model for authenticating any digital data. It is a set of computations to generate a unique code for the input data. And any minute change in the input data will change the resultant hash value. And some of the standard algorithms which I use are MD5, SHA-1, and SHA-2. And this has been mentioned in the IP Act also with reference to the digital signatures. So we'll just see what is hashing. So hope you can see happy to meet all. So the two algorithms, MD5 hash and SHA-1 hash, I have calculated, and some values have been obtained. Now, the second statement is the same. Semantically, it's the same. Happy to meet all, but the capital H has been changed with a small h. And if you can see the hash value here, you can see that for the MD5 hash, if you can compare it, the values are changed by more than 50%. SHA also, the changes are more than 50%. So this is the beauty of the hashing algorithm. So even if you make a minute change, the hash values are going to change by an enormous amount, so that you cannot identify what was the change basically that happened. Now, you can make a claim that the investigator he made the first statement, happy to meet all, then he tampered with happy to meet all, small h, then again, if he just goes back to capital H and does the same activity, will the same hash value be created? But this is what I am telling about is just 4 words actually. But when the same activity is done on a computer, what happens is, there are, what I mentioned earlier, there is a file system metadata information. So along with this data, the file system metadata is also going to change. So in effect, what happens is the hash value, you will not be able to generate this hash value anywhere in the future, even after you do it and undo it. Okay. So another example is cybercrimes are increasing day by day. Cybercrimes are increasing day by day. So you can see here, the capital C has been changed with a small c. The hash values are changed by a huge, enormous amount. And another important feature of this hash value is you cannot regenerate the hash value from the original data. So what does it make sense actually? So as I mentioned earlier, we were about to recreate the hash, undo the activity we had done. Then again, we want to recreate the hash value, but that will not get the hash value. And also this hash value is just like juicer type of device where everything is fused into a unique number. You will not be able to separate or segregate the data into the original format. So that's the way the algorithm has been developed. Now, that was what we mentioned about hard disk. But when we now look into mobile phones, the methodologies are going to be entirely different. The architecture model of the internal storage or mobile phones are not known. This cannot be removed as an SD card or a hard disk. So how do you do a hashing of a mobile phone? So the only entry point is you have to trust the operating system of the phone. And the operating system of the phone might be an Android, Apple, or a Windows or a BlackBerry phone. So what we basically do is we try to insert an agent into the phone. Agent in the sense, a software application into the phone. And now we calculate the hash values. Now, I have violated the principle of forensics in this step because you were to ensure that you are right protecting the device and nothing should go into the evidence. But the standards of hard disk are entirely different from mobile phones. Considering the first statement, you do not know the internal storage. So even though you are inserting an agent into the or an application software into the phone, you are doing under controlled conditions so that you ensure that none of the data associated with the users are changed. That means the WhatsApp, the contacts, the call logs, or any other for the pictures, the files, any other information which is stored relating to the user who is using the phone is not changed. Only some data within the operating system is going to change. That is, an application has been inserted and it is not going to make any change onto these files also. So that's the way a hashing of a mobile phone happens. So the total hash value of a mobile phone will be different at different instances. So at the scene the investigator has taken it. So again, we are going to take a hash value, take say some 4 or 5 days later, you are not going to get the complete hash value the same, but the hash value of the individual files will remain the same. And that's where the veracity of the evidence will remain. The individual files hash value, that the data hasn't related to the user hasn't been tampered with. So why I was stressing on this point is because earlier we all knew about hard disk actually, but most of the evidences are of mobile phone. So the hashing, again, if the court asks for a re-examination, the hash value of the total content of the mobile phone will be entirely different, but the individual hash values will remain the same as long as no tampering has happened. So once the hashing has been done, the investigator, what he does, he stacks it properly, numbers it, wraps it properly as per the judicial methods and sends it to the analysis lab. And also, it's always advisable on the part of the investigator to have a chain of custody format, even though we are not following it properly. So what chain of custody ensures that is at what point of time the evidence, we have a MO receipt format, but a chain of custody format is that the evidence was captured at this point of time, it was transferred to the FSL at this point of time, from FSL it was received at this point of time, it was sent to the court at this point of time. So it's a movement register of the evidence actually. Now, in our Kerala scenario, most of the cases are which are confiscated by the police officers, they are sent to the court and the court redirects to the FSL for analysis. But in other states, what we have observed is they have a Malkhana something, so it's directly forwarded from the Malkhana to the concerned forensic science laboratory. So authentication is the process of identifying. So at the FSL, they need to ensure that there is no tampering because it's a separate entity. The investigating is a separate entity, forensics is a separate entity. So the forensic scientist has to ensure that there is no tampering within the evidence before he commences his investigation. So what he does is he recreates the hash value if the investigator had done at the premises and ensures that nothing has been tampered with. And once this has been done, he ensures, the forensic scientist ensures that the data hasn't been tampered with, the hash values are one and the same, which has been, as was forwarded from the court. The next step is you should never work on the original evidence. So the first step, what will he do is he will try to create a copy of the original evidence. So what is a copy of the original evidence mean actually? Because we also make a copy every time, because from a hard disk we make a copy of the file, from a hard disk we make a copy of some folders, some emails and so on. So what is the difference between normal copying and this copying? So here again, also whenever a source device is connected, you insert a write blocking device in between, and the same process, the diagram as was shown in the hashing part. Like this, you connect the source media, connect a write protecting device. Now you have an imaging device connected application running here. So that will do the copying all the contents from the hard disk to the storage media. Acquisition is done with the write block environment, is normally done after the processor, and it's so why do you want to do a forensic imaging? You want to make a copy. What is the necessity of it? One is it's as I mentioned earlier, whenever you insert a pen drive, there is a possibility of tampering with the evidence. So you need to ensure that the evidence doesn't get tampered. Now, the second important point is, now if you connect, take for example your a pen drive, which is a suspect device. Every time you connect it to some evidences, there is some communication happening within the computer. But if you copy it into a format so that it's a read-only file, you cannot write anything into it. That means it ensures that the contents are safe. It hasn't been tampered with. And you can do n number of analysis. It can be given to first FSL Kerala, then it can be given to CFSL Hyderabad, can be given to CFSL Delhi. At any point, the same image file can be replicated and sent, which is equivalent to the original evidence actually. So that's what the concept of forensic imaging. And also at a later point of time, the defense cannot make an argument that you had inserted something into it because this is a read-only file. Then there is no virus into it. There is no malware which has introduced in it. So it's a read-only file. It's a container which can be you read only using certain applications which are specifically for forensics. So that imaging process is known as acquisition, and we have two types of acquisition, which are physical imaging and logical imaging. I'll just show you. So this is what physical is. So suppose you have a hard disk. So you connect it to a equipment like this, and it gives an exact copy of the hard disk. Exact copy in the sense, starting from the first to the last point, every sector. It's not that because when you have a 1 TB hard disk, but when you connect to the computer, you just see you are using some 80 GB or 100 GB. It's not that you're copying 100 GB, that you are copying 1 terabyte of data. So the 1 terabyte of data will be, suppose this is your suspect media, the internal hard disk which you are seeing here, that will be copied to an external device in a read-only file. That means you have it 1 terabyte file that will be analyzed. Okay. And the second type is logical imaging. Again, coming to the case of mobile phones, you cannot remove, just as we have connected a hard disk here, you cannot remove the hard disk, the storage media from the mobile phones. So in that context, what we do is we insert an agent into the device and we try to extract all the copy of all the files from the device. So this is the success of this depends on the make, model, and on the context on which you are working. For example, to make it clear, there are phones with Android 11, Android 12, Android 10, Android 9. So there might be people who will be upgrading their Android 10 to Android 11. So you have a Samsung phone which is Android 10 and another, the same model of Samsung phone which is Android 11. And the company Android 11 will be coming with more security updates, more security patches so that your data are more protected. So the normal question which we hear is actually, you are able to get that same data from Samsung 10, Android 10, the WhatsApp information, but that information is not available from the same Samsung phone when it was in an Android 11. What is the reason? The reason being, whenever the operating systems are upgraded to the patch, so whenever we're using the phone, we normally see updates are available. So normally every person updates their phone actually to ensure that their phone isn't harmed. So whenever they upgrade their phone, the patches are also installed, the security is also installed. So when the security becomes more rigid, the way you can, because how are you reading the data from the mobile phone? By inserting an agent into the device. So that means if the operating system doesn't give you the permission to read those data, you are at a big stake. You are not going to get the data. So that's the reason why when it comes to mobile phone, In certain cases, you will be able to see physically the data, but you will not be able to get the analysis report because you were not able to copy that data properly. So this is a challenging part for hard disk. The internal structure, how it is manufactured, it's all returned, it's all made in the public. But in the case of mobile phones, it's a platform dependent, it's a device dependent, it's a manufacturer dependent. It's not disclosed in the open public domain. So that's the difference between a physical imaging and the logical imaging. So in a nutshell, it's actually imaging is you need to make a copy of the evidence and you need to work on that evidence hereafter. And once the image has been made, what you do is you have the workstation, you have the computer, you have the forensic analysis tool. You try to extract all the data, what is pertinent to the investigation. So if it's a fake certificate, you look for University of Kerala emblem, the governor's signature, whether he has installed any editing softwares. So many questions can, what was the last time something was communicated? So many information which may be related to the case can be obtained. And suppose there's another case of what you call source code theft, some IP theft. So you need to identify, if you need to compare with the original one and see if a copy of that one exists or a part and parcel of that exists at any point of time. And analysis will be done on the copy and analysis should be repeatable. So this is an important point, and that's the reason why most of the laboratories which are ensuring cyber forensics right now, they also adhere to the 17025 accreditation. It's the equivalent accreditation of NABL, which states that anything which is done in the lab is a repeatable process. Just as you went for a corona test, you had a examination done, and then what happens is that they again redo the examination 2 or 3 times, and finally you get the same results. That means any repeatable activity, you will get the same results. The analysis environment, it should have sufficient tools and infrastructure to undertake the examination. The tool should be tested and certified by national and international agencies. The hardware should be calibrated and quality assessed. It's just like any testing laboratory, your blood sample testing laboratory or your structural testing laboratory. Any testing which is, it should be in a repeatable fashion. Under the same conditions, you will be able to get the same results at a later point of time. There are tools which are open source tools, proprietary tools, and you need to ensure that you use a certified tool. And there's one clarification on this point actually. Internationally, NIST has a list of certified tools, but in India, we haven't come up with a certified mandate which says that these are the certified tools and you need to use this so far. So in analysis, again, you look at keyword search, emails, files, images, pictures, PDFs, anything you look into, what is an important, what becomes pertinent to your examination. And mostly people you can do the analysis of the deleted files actually. So basically we can get a deleted file, and now getting a deleted files becomes more challenging. So I'll tell 4 scenarios actually. Take the case of a normal old hard disk, which we had seen in the diagrams actually, internal hard disk, which come with computers. So our computer we use randomly only. We are not working on a 24/7. So that means once you delete the data, the possibility of overwriting the data is very minimal because we are not working on 24/7. Take the second case of a CCTV camera, which has an internal hard disk, which is storing the data. Every day, the CCTV is going to store 2 GB of data. That means 2 GB is going to be written every day. So at the end of 30th day, suppose the storage gets filled up. It's 31st day, it has to write somewhere. So what it does is it overwrites the data on the first day. That means you are not going to get the deleted data in the case it is overwritten. And that's the reason why in most of the CCTV footages, when it's a very long period since a crime has been committed, it's very difficult for you to get the, because normally our investigations rely on the neighborhood cameras because we don't have a centralized CCTV camera across all the states, across all the major establishments. So it's with the ATM camera, the shop camera, the house camera. Those will be the cameras which will be looked into for any vital information. So that's the context of a deleted file in the case of a hard disk. And again, you have a SSD files, SSD storage 512 GB, faster storage medium. So there also getting a deleted data has become a very difficult process, because whenever you're going to delete the data, what the SSD does is it tries to shrink the storage so that more area is available. So if you look into the storage space of a SSD, it's 256 GB, 512 GB. But your storage on the internal hard disk, you have 1 TB, 2 TB, 4 TB, 8 TB coming up. So the storage space is a constraint for SSD. So they have an internal algorithm which shrinks the storage whenever a free space is available, so that your data is exhausted forever. Again, coming to the mobile phones. As I mentioned earlier, if you have an complete entry into the storage user space where the security systems has been compromised and you are able to get the files, you will be able to get the deleted files. And that's a question which most of them, why couldn't you get the deleted WhatsApp file? Why couldn't you get the deleted Telegram files? Why couldn't you get the deleted Facebook files? Because these are the most oftenly used social media platforms for communication. So the reason being, it depends on the security of the phone actually. So the tool which you're using doesn't have the proper technology to surpass the security of the phone, you will not be in a position to get those informations. So normally you rely on a manual information which is observed from the phones. And again, signature mismatch is another point actually. Signature mismatch is people normally rename the files, and there are certain times where try to get a part and parcel of the file, then can you recreate the file? So that's a terminology of scarring. You get a bit and parcels of the data. Sometimes you will be able to recreate the data. So there's a huge way of doing the analysis. And once the findings are done, it should be recorded in a paper format or in a storage medium along with the report. The reason being, whenever you make a report, these are the data which comes as part of the analysis will be a GB files or some KB files of it. But if you're try to make a printed format of it, it's going to be a huge pile of files, papers. And that's the reason why normally we add on a pen drive or a storage medium along with the report. So that will be played later in a court to see what is the contents of it. Okay. Finally, presentation is the technical aspects, what the forensic scientist has found out. It should be in an easy to understand format for the legal system. Maximum technical jargon should be avoided. And there should be a proper format where what is the nature of the crime that was requested, what is the infrastructure on which at which was present at the lab, and what was the equipment that has been received at the lab, and then what was the analysis, observations, then finally conclusion of the report. Finally, you need to preserve these evidences, and preservation gains an important momentum. Just to give an example, actually, we all used to hear MP3 songs on our audio sets within our vehicle, which was an MP3 CD. And now the new generation USBs have come, so the MP3s has been set aside in our home. One fine morning, we want to hear these old Rafi Kishore songs. You just take up the CD drive, you find that most of them are not working properly. The reason being, it being a digital device, there has been some due to wear and tear or rust, scratches, it isn't working properly. So the same can happen to digital evidences also. You are keeping your digital evidence intact for a longer period of time. And one fine morning, you are going to take it again. Will it work properly? So that's the big challenge. So hard disk, as you know, your computer itself, after 5 years, 6 years of usage, your hard disk gets corrupted. So how are you going to preserve it for a longer period of time? So the normal procedure is it should be enclosed in glass chambers and kept so that it is free of fire, electrostatic interruption, and such disruptions actually. But that's not a feasible solution in a country like India. So what we do in our labs are actually we bubble wrap these devices, put on anti-static covers, and keep it in a shelf or almirah with a proper numbering. So far, it has been working fine, but over 10 years or 12 years down the line, may not be sure that hard disk might be working fine or not. And I think as part of the e-courts project also, which C-DAC, Noida and Mohali is taking up along with the Supreme Court, they're planning to have a structured architecture where all the evidences which are captured at the front end is stored in the cloud according to the case. And finally, even if the source devices doesn't work properly due to this preservation issue, the evidences can be obtained from the cloud at the magistrate level, district levels, 4 or 5 level of authority, how the data can be taken. I'm not well versed on that project actually, what is e-codes. I know that there is something like this on the policy factor of e-codes also. And the original evidence can be retained. Evidence should be stored in a cool place. Mechanical forces should not be applied and proper packaging should be followed. So finally, everything should be presented before the court. Court can invite as an expert witness once you are presenting your report. Now coming to the standardization. So I have been putting all the blah blah for the last half an hour. So where does the standards come from? Who gave you the authority to do all these activities actually? In India, we don't have the standards actually. Most of the standards come from the NIST guidelines, which is under the National Institute of Justice of the USA. And they have released guidelines for each type of evidences. And there is also another group, which is a software working group on digital evidences. They also released standards on various devices. So these are all standards come from the USA, and we comply and adhere to these standards only. Now, there are also ISO standards for this, how to preserve, how to collect, how to, they are mentioned as ISO 27037, 27040, 27041, and 27045. Now, for example, I just mentioned a NIST guideline. This is what a NIST guideline for a hard disk looks like. The tool should make a bitstream duplicate or an image of an original disk or partition on fixed or removable media. That means you will make a copy of the original forensic image of the original one. It should not alter the original disk. That means you need to ensure a protection device. The tool shall be able to access both IDs, SCSI, and SATA disks. All interfaces should be protected or supported. The tool shall be able to verify the integrity of a disk image file. That means you need to re-ensure that the hash values can be recreated at any point of time. The tool shall log IO errors. If there was any reading error from the device, that should be supported, and a good documentation. So this is what the requirement of a hard disk, a tool which has, which can cater to the forensic imaging and hashing of a hard disk has to be as per the NIST guidelines. So this is that standard actually, just the front page for information. And any lab which conducts this analysis, they internally need to have a standard operating procedure, and the policy has to be defined. And now, as all of you know, are aware, under the IT Act, there is a clause which is known as the Examiner of Electronic Evidence. This means that those labs which are accredited by the Government of India, hereafter, they will be certified to do cyber forensic examinations. And with my minimal legal information, please excuse me if I'm wrong, the medical practitioner who does the forensic science, the chemical examiner, the ballistic examiner, they have all been mentioned in the CRPC clearly. But who has to conduct cyber examination and what is the qualification, that hasn't been mentioned there. So that comes under this Examiner of Electronic Evidence. And so far in the country, only 8 to 9 labs have been accredited. So there's a long way to go ahead before all the forensic laboratories in the country are getting accredited. And guidelines have also come into, and how it has to be adopted to the Indian context. It's still a growing area where policies are revamped and again put into practice. So with that, I'm about to conclude my session. Gadgets are increasing day by day. A lot of research has to go into this. The standards are also still evolving. So there is not an antidote for all the forensic problems actually. And we need to go by device specific or the standard specific format for addressing each issue separately. With that, I conclude. And Shyam sir, I'm happy to have any questions from you.
Thank you, Nabeel. That was a wonderful presentation, and that to articulate and put into such a short period of time. Now, may I request Bhadran sir, before we open up for discussion, to offer your comments on the, as a concluding remark to the formal session.
It was a very nice presentation by Nabeel.
Sir, you are not
about-
visible.
Not audible.
Audible but not visible sometimes.
Oh, okay, okay.
Yeah, very much.
It was a nice presentation by Nabeel. Basically, how we do the forensic, that was very well taught by Nabeel. And I have some observation regarding what has been told and what Sushanth also mentioned, that we have a lot of change coming in the way we handle digital devices, because every day the power of digital device changes. Every day the way they store the information in the digital device change, and more every type of device are going to protect the privacy. And that's where we cyber forensic analysts or maybe cyber forensic engineers are facing a lot of problems, because when all the manufacturers go and improve the privacy of the devices, and the issue of getting that data from the device becomes more and more difficult. That's one important thing which we are facing now. And so recently we had a problem with the what do you call it, Mac laptop. So one of the laptop, they use the memory embedded into the motherboard. You cannot get it outside. That's one issue which we face. Even if we lose that access to the system, then the data is lost. Both happens. If it is an evidence, we cannot get the evidence. So that's one thing which we found very difficult. Then the second thing which I noticed is that the procedure, we have a forensic procedure, which basically we used to follow from 2000 onwards, 2002 onwards. We have developed the procedures. We are following that procedure. But even if we say that you should use a procedure, at our place, we don't have that much facility. So the investigators don't follow the procedure. So what we get is a digital evidence into the lab, then we examine it. So up to that point of time, when we get the evidence, it may be hash or it may not be hash. So we will never know that whether it was tampered or not. That's one issue which we normally face, because even though we say that from the scene of crime itself, it should be hashed and taken to the court and sent to the lab. That was a procedure which we said. So it's not fully practiced now in Kerala or anywhere else. So I can tell that today, most of us know that we have something called a hash value, thanks to the case of act of belief. So everybody knows that there is a hash, and hash can be modified and that things like that. So Nabeel explained the issue of the change in hash value very neatly, so that you can follow that. Then one of the things which we face is the tools itself. If you look at the mobile phones, we don't have a tool which can extract data completely from any type of mobile phone. So Nabeel mentioned that Android 11 phone or maybe iOS 11, etc. You may not be able to extract, physically acquire the data from the mobile phone. So what we do normally is get the logical thing. But unless you get a physical extraction of the mobile phone, you may not be able to get back the deleted files. So tools also are not supporting the digital investigation. There's a lot of research going on, but till we don't have very good tools, which we can say that, okay, it will support digital investigation. And my final remarks to the legal community is that I had an occasion to discuss with Justice Mini S. Das, now the Sessions Additional District and Sessions Judge. So she asked me a question when we had the discussion about the cyber forensic. Do we have a law for digital evidence? And if we say that we don't have a law for digital evidence, so what we have a cyber law which is supportive of maybe transactions on the internet, or maybe something that which we adapt to the digital evidence. So it is high time that people think about whether we can have a law for digital evidence which will help us directly to admit the digital evidence in the court. Now, what happens is, even though we have a digital evidence available, we have to prove that that's a digital evidence which I analyzed and got it from this device with using this method, etc. So even though it may take a lot of time, but I think it's always good to make a start in this direction. So that is my observation regarding all the cyber forensics, which with all my experience in the field. And that is, as a concluding remark, I would like to say that don't expect that cyber forensic will help resolve all problems in investigation and analysis of cases. Sometimes we may not be able to get the evidence from the device, so we are helpless in that situation. So thank you very much for all the listening to me, and I think this type of sessions will improve the knowledge level of legal practitioners, so that they can take it up in the court very efficiently. Thank you very much.
Thank you, Bhadran sir. With both you and Nabeel on the platform, one doubt I have is that in view of section 79A, wherein examiner of electronic evidence has been specified and now notified by the central government, can any other agency or an individual who are not accredited, I'll just read 79A for the benefit of all the viewers. The central government may, for the purposes of providing expert opinion on electronic form evidence before any court or other authority, specify by notification in the official gazette any department, body or agency of the central government or a state government as an examiner of electronic evidence. Explanation. For the purposes of this section, electronic form evidence means any information of probative value that is either stored or transmitted in electronic form and includes computer evidence, digital audio, digital video, cell phones, digital fax machines. So section 45 of the Evidence Act says expert opinion can be taken. Special statute says who is an expert as far as electronic evidence is concerned. So does that rule out any other form of expert evidence, or rather evidence being adduced, than by those persons, specified by notification in the official gazette by the central government?
What I understood that is basically the notification is regarding not an expert. It's basically an expert body, like an institution, which is doing the digital evidence analysis. That is basically the notification is about. It doesn't mention about somebody who does the actual examination. So if it is 79 certified lab, then the government says it can be directly accepted.
Sir, is C-DAC Trivandrum such a notified body?
No, sir.
Not yet.
So far in the country, only 10 labs have been accredited.
In the 10, C-DAC is not included.
No.
FSL only forensic lab.
Forensic labs, okay.
Yes, including forensic and
defense laboratories. Defense laboratories, actually.
Defense laboratories.
I think the CBI laboratories are accredited, appears.
Yes, sir.
So we are coming directly to Ramachandran, your comments.
No. No, I am a blind man looking at the elephant because we are not very familiar with the digital evidence. Because by the time I retire, the digital evidence has not. I have no occasion for me to deal with those things. But we had an opportunity to have a seminar at Trivandrum during 2007, 10 or something, when Justice Kurian Joseph was the Legal Service Authority Chairman, Kerala Legal Service Chairman, where the then Chief Justice of India, K.G. Balakrishnan, and certain judges have come for that meeting. We had some idea at that time because the manner in which because at that time it was not very familiar also, and people may not be knowing how it can be stored. And there was a concept that you cannot give a certificate. It is a tamper-proof document that has been produced before the court. Unless those things are certified, it will be very difficult for us to rely on that evidence. Is the conclusion we arrived at that that seminar. Similarly, you also mentioned about suppose the C-DAC is not the authorized agency. What is the evidentiary value of the certificate or authentication given by such an agency when it is produced before court? Can it be relied on? That is a main question where when cyber crimes comes, it's a technical issue.
Correct.
And the technical defense also. Because when a particular statute says that only particular persons are entitled to do it. And I don't think that even just like the section 292 CRPC and 291 CRPC, it can be straight away because even in the EP Act, there are provisions where certain agencies were accredited for the purpose of doing certain analysis, and those analysis, those evidence can be put in evidence directly, and that can be used as an evidence without even examining the person who have prepared it. Because just like in the Food Adulteration Act, the certificate, if you want to disprove it, you will have to call them back. Because there is an authentication has been provided by the statute that need not be proved, it need only to be produced if it is been done. The burden is on the other side to prove that it is not properly done.
Mhm.
So can such a protection has been given as far as these reports are concerned? Because once that protection is not there, under section 291 CRPC and 292 CRPC, which gives a protection of certain certificates which have been prepared by a notified agencies or analysts, then that can be put into evidence because that can be proved through the investigating officer. You need not call for the expert for the purpose of proving that. I don't think that such a, probably the question that has been put to Nabeel by the session judge was whether such a protection has been given. I don't think that such a protection has been given either under the IT Act or the CRPC. You can only rely on CRPC provided you have got all the protection that has been provided under the CRPC by virtue of that authentication given.
Correct. Actually, what we are doing is we are giving the deposition as an.
No, not only that, if I on hearing you, Bhadran, I feel very difficult for, because if whatever thing you have done, if it is not useful or you are not able to provide foolproof certification to the effect that the evidence that has been collected is foolproof, which can be relied on for the purpose of fixing the liability on a particular person. If that is not possible, what is the evidence? What is the purpose of collecting the digital evidence for that purpose?
Correct.
One, that is the one thing. See, as regards the, why can't suppose in a case where the site inspection is being done, in the scene of crime is being done. Normally, in the case of a cyber crime, the medium will be the crime, the scene of crime. Normally, so if that be the case, just like you are calling for forensic evidence, these experts, for the purpose of collecting those materials which are expected to be taken for the purpose of the analysis, why can't they get the assistance of those digital experts? You can call it as a digital expert or cyber crime experts or technical experts for the purpose of collection from the place of crime itself. Why can't such a cell be created in the forensic lab itself so that they can get the assistance of those persons for the purpose of collecting evidence, so that whatever possible thing avoid tamper by the investigating officer before it is being sent.
But sir,
What I'm suggesting is it not better for the government when the cyber crime department has been separately launched for the purpose of doing the investigation of the cyber crime, etc. Why can't they think about the establishment of such a procedure also for the purpose of collecting evidence? Because collection of evidence from the place of crime is the material thing.
correct.
Because as far as the cyber crimes are concerned, it is a media that is being used for the purpose of committing the crime. Suppose the media itself has been corrupted before collecting evidence, or during the time of collection of evidence, due to not having much knowledge about how the evidence will not be collected, or how the stored material will not be collected.
Sure. Correct. Correct.
So is it not better that you evolve a system, because these are all the areas where you are also in the initial stages? Why can't we evolve a system by which, just like persons going in a normal crime, you are calling the expert, the forensic expert for the purpose of collection of the hair, mud, sample, etc. Similarly, an expert on the person who is able to collect the evidence from the media can be accompanied along with the investigating officer for the purpose of collection of evidence, when they know that this is the evidence that they are going to collect. Maybe they may not be sure about it, but at least they may know that they are going to collect media which is having some material which will be helpful for them to give a clue as to how the crime was committed. Is it not?
Sir, currently in Kerala we have.
No, I am not at that. It is for you people to suggest. See, government may not be knowing, or the investigating agency may not be knowing, the court may not be knowing about how this will not be collected, how your evidence can be believed or not believed. See, when a standard procedure will not be provided for the purpose of collection of evidence, in the CRPC there is provided, in the forensic, what you call the in other enactments, it has been provided how the method of collection of evidence, the materials or sample will not be taken. Whether such a procedure has been provided for you, incorporated in any of the statutes which deals with cyber crimes, for the purpose of how the collection can be made, for the purpose of make it foolproof. No, we are on the initial stages. So unless you people can suggest that this is the way in which amendment will not be made, this is the way in which the procedure will not be provided for the purpose of collection of digital evidence, otherwise the whole, whatever the effort you have taken will be of no use, because your evidence will be thrown out in a court when it is come. Just like persons like Shyam was cross-examining an expert, saying that we have done this or not. You will have to say no. Your answer will be no, or I am not sure whether there is any tamper has happened or not. Because even now you are saying you can get a different hash value, but you cannot say what was the original text and what was the nature of changes been made. If that is there, how can you say it is fabricated? Only thing is you can say their hash value is different. There is a possibility of manipulation in the document. Is it not?
Yes, sir. The procedure was created in long back, 2005 itself. We have created the procedure and communicated to the ministry, but things are not moving that fast.
No, it is not that. It is not the question of how you are. It is only a suggestion. It goes on as a suggestion from your side.
Right.
Whether any steps have been taken in connection with the law department in the central government law ministry as to how the IT Act will not be amended for the purpose of getting an authentication of the digital evidence collected to be proved in court. Just like if you go to EP Act or in the Water Act or in the Food Adulteration Act, there is a procedure provided how the sample will not be collected, because you are wrapping in different methods, putting this, get the signature of the witness, get the signature of the accused itself, because it is being collected in his presence. So all those things are given what you call gives an authentication of the collection of sample, because there is no possibility of tampering. And also you are giving a sample to them also. What is a sample that have been collected will be given to them also, so that if you are having any difficulty with your result, they can send it to another agency to get it corrected, get it analyzed, to say that whether your result tallies with them or not. Such an opportunity is also being given to them. Why can't such a method? I am thinking about it, because these are all new area where things will have to come, because you are in future, everything will be on digital crime only.
Yes.
Even murder is happening in the poisoning is also being introduced on the human body using a robot or something like that, and it is being programmed.
Very
So
true.
if such a things are moving, because when the criminal is becoming more intelligent, unless the investigating agency is also getting cope with the intelligence of the criminal, you may not be able to suit with them. You will be nowhere. So this is the area where I think that a lot of things will have to be done from the government side also.
Yes.
Because you alone cannot be the agency. For example, in Kerala, there is no accredited agency who can conduct the expert evidence. So whatever things done by C-DAC and it is produced before court, it is just like an other expert evidence, just like in section 45. I may really rely on it or may not rely on it.
Sir, Kerala State Forensic Lab is now accredited 79A.
Hey,
State, yeah.
no, because somebody was telling that it is not. That was the reason why I said.
No,
Among
it's
the
one of the
10,
lab.
I think
One
we
of the
got
lab.
one in Kerala.
Huh?
Among the 10, one in Kerala.
No, one in Kerala, C-DAC is not one.
No,
Most
C-DAC is
most
not
of-
one.
No, most of them is going to C-DAC only for the purpose of, because they're supposed to be the having all expertise in that.
the
All
pioneers,
huh?
the pioneers in the field.
A pioneer is the field. All evidence collected by the cyber investigation agency is being sent to them only. I don't think that they are getting the accreditation, the accredited agency using for that purpose. I do not know.
Ramashan sir, there is yet another difficulty because the special governs the general. So even if we say for section 45, when 79A says these are the persons who can.
No, I am not at that. I am not at that. They can only do it. Unless it is not done, it is have no evidentiary value at all. Even
Correct.
it cannot be admitted in evidence.
Correct. Earlier, we could get a site blocked by certain Computer Emergency Response Team of India. But once it was included in the statute and the powers were delineated specifically, that power is no longer available. And we'll have to go to a civil court, get a injunction order, then transmit it through the procedure that has now been prescribed. But earlier, certain had the power because it was not, till recently, these 10 places were not declared or notified by the central government. So everything was okay. Once the declaration or the notification came, the difficulty arose.
No, anyhow, it's an area where a lot of things will have to be done, research will have to be done. And also things will have to be introduced in the law itself as how the digital evidence can be dealt with. Probably, I think that nobody may be knowing about the exact, because just like a letter, I can say this is a letter written by so-and-so, so-and-so. But in the media, it may not be said whether it can be created by anyone.
So,
Even
and
using.
and for that matter, all cases of Kerala police are post 2012, I believe, goes to this forensic FSL, right?
Yes, sir. Yes, sir.
It goes to FSL.
Yes,
Right.
goes to
Correct.
No,
Sure.
FSL is also, I don't know, FSL is a accredited one.
Yeah, yes, sir. Exactly, sir.
And they are accredited.
Yeah. In the year 2020, they have been accredited.
Recently only.
In recently.
No, till then, whatever evidence collected will be of no use.
Sir.
Okay, thank you very much, Isabel and Bhadran and Subhash. Because it's an eye-opener for everyone. Because everybody searching in the dark. How the digital evidence will not be used, how it can be proved. Thank you very much.
Thank you, Justice Ramashan
Thank you,
sir.
sir.
We have Advocate Prem Kamath, who has been in this field for quite some time. Let us hear his comments as well.
It's not a comment, I have a question.
Shoot.
Mr. Nabeel.
Yes, sir. Yes, sir.
Question is to you. Sir, you were elaborating about extraction of evidence from a mobile phone, which is very different, which I also understand in my limited knowledge, that from a hard disk, it is different from the way it is extracted from a mobile device. But my question is, in case where you have a mobile device before you and the device credentials are not known to you. So in layman's words, it's a locked device. In such a scenario, will it be possible to conduct a forensics examination by introducing an agent and to extract or hash? Is it possible?
Yes, sir. It depends actually. It's not 100% successful every time. But in those cases in which we are successful, the pin can be unlocked through some vulnerability of the phone or some unpatched versions of the phone, and or some other intelligent guy might have written a script which can be utilized to bypass it. And using that, you can unlock it and you can get into the phone. And when you are unlocking the phone, you are just going to the operating system part or the Android part, the core part where the security is managed. You are not touching any of the user data part. None of your contacts, your call logs, text, SMS, WhatsApp, nothing is going to be touched up, or your files, notes, nothing is going to be touched up. So you can ensure that the data hasn't been tampered at, is not getting tampered at any point of time. Only that is doing is you are surfacely, on the surface part, you are trying to bypass the lock and get entry into it. And in certain cases, certain phone, this is also the vulnerability of the phones that has been utilized actually. You, without unlocking the phone itself, you try to, certain applications try to give you access to the contacts and the call logs. I hope that is a model which we usually use actually.
Yes, there's an addition to this, which would be my last question because there are other people also who are waiting. What I would like to ask is, suppose we extract data from a mobile phone and then we extract the data on another removable device or whatever. As you had stated that the basics of forensics is that you don't work on the original device. So once we extract data, is it the device on which the data has been extracted for forensics, you create only one master copy or you create two copies? Is there any procedure for this? Suppose in a situation where a report comes and they say that there is only one copy which has been created and forensics has been done on that, can it be a reason to state that there has been a lapse in the forensics procedure? If I'm clear, I don't know if I'm clear.
No, sir. You can tell that, as I understand it from your question, you make a copy from your phone to a pen drive.
Yeah.
That will be a master copy.
Yes.
You can make n copies of this because whatever you have made is a read-only copy.
I agree.
No,
But
the doubt of Prem is that once you tamper with it, or rather once you do your investigation on that, and if I'm challenging it, can you prove it without having another similar copy that it is on that or this is the product? If a third-party expert is to be called.
Yeah, that's what I'm answering, sir. Because the data which is residing in the pen drive is a read-only file. That is, you will load it in your application. You will not be able to enter any data into it. You will be only able to view the data. So
Right.
that means n number of times if you make the copy, you are going to get the same file. It is as if just you have a audio file. You make.
I agree.
Yeah.
My question is only if the situation where a forensics examiner creates only a master copy and does not create a working copy. In such a situation, can it be stated that there is a lapse in the procedure that has been taken?
No, sir.
No.
No.
Fine.
Because the situation comes like this actually. Normally, sometimes the investigating officers, they also just want to go into the further investigation. They need a copy of this. So we make a copy for the court and copy for the IO. But even if we stop with one copy, that doesn't make an issue because this copy, we ensure that this copy doesn't change at any point of time. So at later point of time, if you make it, doesn't make any issues. That's what I understand.
Thank you so much. Thank you so much.
Basically, when we tell that we are extracting, we are creating a copy of all evidence in the mobile phone as a single file.
Yes.
It's not just copying it to a file.
Right.
There is two things. One is creating, imaging a device and copying a device. That's the difference. So if the imaging is done properly, then that we can use in the.
Sure. Thank you.
Thank you, Prem. Nice to see you. And Vikas, please.
Yes, sir. Good evening, sir. My question is, examination of private lab expert is admissible in evidence or not? And how can you confirm that wise sample pertains to accused as no sample is taken from accused? And he will say it's a violation of his fundamental right, Article 20, if sample is taken.
Sushanth, sorry, Vikas, that does not pertain to the technology, but still with Ramashan sir also here.
No, I don't think that the collection of voice is not a fundamental, the violation of fundamental rights, because just like collecting some blood sample, collecting this thing, it can be done. Nothing wrong in it.
But normally, sir, they denies for
No. Your denial is a different thing, but blood sample you are taking, semen is taken,
doctrine of self-incrimination may not come into play in those things.
No, you are only verifying whether you are the person or not. It may be helpful for you also. It cannot be said to be an incriminating circumstance, or you are admitting that it is my voice, so I am giving it. No, it is only to compare your voice with the available voice to say that whether it is probably whether you have done it or not done. So collection of voice, I think recently Kallu's case or something like that in 1965, the frame may be able to give. That was reiterated by the latest Supreme Court decision.
But family court normally don't allow, sir. Family court
That is
normally
DNA
don't.
fingerprinting. That we have got couple of Supreme Court decisions.
DNA stands in a different footing.
Yes, and that too, it is said that when the child is the applicant and want to know the biological father, nobody can
That can be
stand.
done. That can be done.
The other thing is you're 1 second, because other thing is you're trying to bastardize the child, which is not
Permissible. Which is not permissible.
There's a word of difference between who wants the DNA test to be done.
Even they said, sir, in family court that communication between husband and wife is not admissible, basically. Recently, Punjab and Haryana give this ruling also.
No, that is because of 126 protection is given.
That is not against each other, but against third parties. But in a divorce case, if I got a communication which shows the cruelty as far as the wife or husband is
that can be produced.
That can be from producing it.
Nothing wrong.
Yes, thank you, sir.
Thank you, Vikas. Before I come to Kevja Rao sir for the concluding remarks and his comments, there are a couple of questions that has been put. May I just share with that? We have Dr. V. Sundareshan. Sir, can you unmute? Dr. V. Sundareshan. Yes, can the cyber criminals be nabbed with the mobile number used for hacking the bank account or credit card? It's a question that he put in the chat box. Yeah, please, Dr. Sundareshan, please.
Thanks to clarification.
Yeah, the question that has been posted, I read out. Anything more to be added before the experts?
No, sir. The same thing I request an answer.
He is traveling, it appears.
Yeah, yes. The question, can I read it once more?
Please.
Can the cyber criminals be nabbed with the mobile number used for hacking the bank account or credit card?
Right, sir.
Bhadran sir,
No, I think Bhadran has given the answer, it appears.
Yes.
So the time what happens, they will use it only once. Then we can get only the last position of its use. If he is continuously using it, then we can track to the person.
No, that is how nowadays the police is tracking the accused persons using the mobile locations.
Correct.
Sir,
Dr. Anil Singh was asking one question. Is investigation different?
Anil, yeah, please. Dr. Anil Singh, I think is not there in the platform now. Is the investigation different from other countries? If yes, then how it is?
The investigation is the same actually, because we are following the NIST guidelines. So the same guidelines applies to most of the countries. And in Europe, they have a consortium called Europol. They have released certain other standards also, in addition to this NIST guidelines.
Thank you. Sadashivan has put the hand up. Please, can you unmute and put the question?
Sir, namaste, sir. Mr. Goel, sir, when a hard disk is sent to your lab, after scanning, you are putting one remarks in a particular scanning report by your C-DAC lab that it is password encrypted. So, what do you say about that situation, sir? Because you said that in your report that the party did not share the password because it is encrypted. You please explain that situation, sir.
Okay, sir. So password breaking is a difficult problem as far as forensics is concerned. So whenever we receive, I think the case might be relating to some hard disk in which some files might have been encrypted, kept in encrypted condition. So we tried with our tools, because there are umpteen number of tools which are available, but the set of tools which have been recommended in the industry, we have used certain set of tools, but we were unable to get those data. So password cracking also takes an enormous amount of time. So for a password, a PDF file, which is an 8-character password, it will take more than 72 hours to 4 days, 5 days actually. So we don't have such a big facility where a password exclusively for password cracking here. So that's why we recommend, if we have the password, we'll be able to do it, or else it will be a waste of our time actually. We will not reach any conclusion. Hope
Okay,
that was
sir.
your
Okay,
question,
sir.
sir.
Oh, nice. But question is that your report, then if you want passport, suppose court is sending the hard disk to you in this
Okay.
particular court is sending.
Okay.
So your report should be, sir, please ask the party to submit the password. But you have not written in that way, but you have said that the password was not shared.
So actually, what that I can clarify is actually, when our court sends us, we are sending the report. We are not sending any further communication to the court actually. So normally what happens is, once we send this report, the investigating team looks into it. Finally, if they find any discrepancy from what we have pointed out, they again send a letter through the court. We directly don't send a
All right. I got the point, sir.
Okay.
All right. Now we understand after the discussion that as per 79A, it is not notified. So if the court is sending such a hard disk to your lab, you must reiterate that, sir, this is not a notified lab to the court, so that the court will understand about the evidentiary value. Please react on this point.
So now the cases which are coming, we just ensure that from the court that we are not accredited under 79A. We give in writing actually. But the problem being, only 8 labs in the country. Out of these 8, only 4 or 5 catering to the civilian requirements or the investigation requirements. There is a huge pendency of cases across the country actually. So the courts are right now, I think they are not so much stringent on enforcing the 79A right now, unless the MIT has to come up with accrediting more labs, because the provision for them is that in the next 24 months, they'll be accrediting 1 lab per state across the country.
Thank you, sir. Thank you, sir. Last point, you can put it in the chat box, the 10 lakhs, so that the advocates who are handling such cases, whenever the judge is asking which lab we can send, we can suggest the name of the lab. So you can put it in the name, the 10 labs, sir, please.
Okay, I'll put.
Thank you.
sir.
Probably that will be available in the website, I think so.
Yeah, from the MIT website, it's available, sir.
Correct. Now, Sushanth, do you want to add something onto this?
Yes, sir. I have 2 questions, very into 2 different directions altogether. Sir, the question is that I have a question to Nabeel as well as Bhadran, sir. So now with artificial intelligence coming in place, especially for cyber forensics, do you think it is a boon or bane? Because using artificial intelligence for evidence analysis can absolutely solve the problem within minutes. But if there is something like a bias, then it can hamper and what do you say? It can hamper the evidence completely. So what is your take on it?
Yes, sir. So far, artificial intelligence hasn't been introduced into any classifying problems or any big problems.
Till date, we have not lost the job.
Yeah, that's it. That's what. So one important point is upcoming problem is this. Just for an inquisitiveness, there's a problem called audio forensics actually. So now what happens is, most of the people are not communicating, texting. They are putting up voice messages on their WhatsApp. So these voice messages doesn't have any metadata. So I send an abusive message to Padman sir. The next day he makes a case with the court. So if they confiscate my phone and look into the WhatsApp communication, they will not be able to trace it at one hand whether I have sent it, because I can send that an artificial intelligence might have created it. AI tool might have created this document or something. Voice.
No, will it not be recorded in the hard disk?
It will be recorded, but I will challenge it. It was not there was some AI application running that might have created it. So it's a boon or a bane, still to be answered, sir. Sushanth, sir.
And thank you. Bhadran, sir, what is your take, sir?
Yeah, Sushanth, actually, the current use of AI in cyber forensic is basically to reduce the search time. Because if you get 2 TB, 5 TB, 10 TB data and analyzing it takes enormous time. So these type of tools will allow, it will scan through the evidences and classify the evidence. These are the pictures available. These are the arms. These are the nude photos. These are the documents available, etc. Then from that we do the analysis. Pick the actual evidence. It is not directly picking up the evidence. It may not be possible also, because the AI tool may not be knowing what you are looking at. So it can classify things and help you in doing the analysis.
Correct, sir. That's exactly what I was trying to say. But in picking them that, will it, if there is a bias, because ultimately AI runs on data and data sets. If there is some bias in that algorithm, so don't you think that in that case, it may not point to the relevant file?
It may happen because
that's
bias is
a hypothetical question.
Yeah, if it is trained to avoid such a thing, then it will not pick that. That's true.
Because already AI codes and AI analysis have already begun in China, where we already have the AI codes for addressing small matters up to a certain limit. So in that context, I just wanted to understand, how do you look at it? That's one question that I have. And the second question I wanted to understand from you as well as Nabeel is that you've been an expert in various cybercrime cases where you're testified in courts. In the absence of any law which talks about how the hash value has to be computed or how the forensic examination has to be done, what kind of challenges did you face, and how did you try to look at that as an expert?
You mean you have given the evidence and in the court?
Can I reframe that question?
Yeah.
Bhadran sir, and for that matter, Nabeel sir, once you say that this is the procedure we have adopted and this is the way in which we have come to the conclusion, there is no legal sanctity or any recognition as such for it, because it's something that you have adopted.
Right.
So what are the challenges you faced in justifying the procedure and the final outcome which you gave it as an expert report?
Because we don't have a law currently which says that the procedure has to be done in this way.
Yes, exactly, sir. So the only comment we make is actually this is as per international standards.
Okay.
Yeah, and normally this is a standard of acquiring evidence and analyzing evidence. So it is basically a standard which is available. So we follow that.
I think as regards the hash value is concerned, there is some standard is provided how you will have to collect it, because it is
the tool is not
the
there,
language. The language is available. You are using the language that has been provided under the particular system, and then you are collecting the value, 00088 or something like that.
Yeah.
So the standard is there. I was just
asking, what is the
tool
legitimacy to that thing?
Tool.
I would say it is just like medical evidence. Like in the absence of clinical guidelines, every time the expert will have to start from the basics, explain, and then produce documents, etc. Otherwise, had there been proper clinical guidelines in place, then there is no problem. Likewise, here we are lacking guidelines. We are lacking certain objective standards. Which could be utilized. Then had it been there, it would have been much more easier for you to establish and justify your conclusions.
No, basically, there is a standard. National Institute of Standards and Technology is the standard organization which creates the standard for forensics.
Had it been incorporated in the IT Act, that would have been more beautiful.
Better. That would have been better.
Because I just wanted to understand how the defense and other people have looked at this point when you were as an expert, when you are giving up your views.
No, not that. I put it another way. Suppose you have been given an expert evidence on a particular issue. On the basis of the expert evidence on the digital evidence that has been collected, is there any conviction based on that? And whether it has been, any decision has been come on that aspect?
Yes,
How
sir,
far
there
it is
are piracy cases. There are cases wherein employees of your establishment have done mischief. All those things have been found. There are a lot of cases that has been reported.
Sir, Uma Shankar versus ICICI Bank.
Yeah.
I think that's one classical case.
And
No,
for that matter,
whether they
Sushanth,
have,
I'll just add one thing.
whether the High Court or the Supreme Court has given a guideline as to how this evidence will have be collected on
No,
base.
not to my knowledge, sir. Not to my knowledge.
No, see, you are only believing. See, just like say, I believe A, I believe C. So I find that there is nothing to disbelieve that expert evidence.
But sir, there is a scientific principle, proven scientific principle, which is infallible. So basing on that, they are that scientific principle, they are developing it. And sir, for that matter, and Sushanth also, Section 45 does not say that you should have such and such standard or anything. If you have a dispute regarding carpentry work, a person who has been experienced in that for so many years is also an expert as far as Evidence Act is concerned. It need not necessarily be a PhD holder in carpentry.
Sir, the only point I have here is that, sir, because when you're doing this hash value computation, see, standard is absolutely agreeable. We have SHA1, SHA2 under the latest amended IT Act of 2008. But my question was that, I can compute it using even foreign tools, basically. So whether the authenticity of the evidence can be established because I'm making use of some foreign tool. For example,
there again, Sushanth, what is the criteria? Can this be rechecked by using some other mechanism by some other expert and come to the same conclusion?
Yeah,
if that is possible.
That's it. Basically,
the absence of a legal backing. That's the whole point.
That of the legal mandate is that it should be credible, it should be unassailable, and it should be scientifically proven. If that is how do we believe DNA fingerprinting? DNA fingerprinting is not ingrained into any statute. But we know that there's a science behind it, and that is accepted. Paternity.
For the cyber forensic, what we normally say that this is repeatable. So we have a image available.
You will get the same.
I am giving an expert opinion, and if you don't believe that, you can call anybody else and do the same thing. So you get the same result.
Thank you, sir. Thank you so much, sir.
Thank you, Sushanth. And while we conclude a wonderful evening, may I request K. Vijay Rao, sir, for the concluding remarks in the sense like of the session.
Good evening, everybody. Thank you, Nabeel, sir, and thank you, Bhadran, sir. It was really nice listening to you. Very well said. And as we said, the science is evolving. Laws have to evolve. Laws are not keeping in pace with the evolving science. And that is going to be another problem. Another thing is, like, even getting our judicial officers to understand what is being said. A little bit of, I'm sure the Judicial Academy must be
training is being given on now. Nowadays, yes, the persons are dealing with cyber crimes. That's what training is being given.
That's what I'm coming to, sir. That's what I just said. So they must be taking care of it, because I know this is repetitive, but I am one of the first persons to have taken Section 66A head on, and I have got it repealed. So now it has been 12 years, or rather 10 years, the trial has not moved in my case. And every day I go to court and I tell them, sir, can we have the trial? The prosecution says, but we haven't got the papers. We are waiting for this. We are waiting for that. I mean, 12 years.
K. Vijay Rao, sir, on the lighter vein, I'll add something. 12 years and your case has not reached anywhere. The Supreme Court had to say again, if at all you arrest anybody on this repealed or which has been struck down, we will hold it as contempt because it is still in the statute.
He said that I'm telling you, sir, mine is still on the record. I've told the magistrate 500 times. I've said, saying that, sir, I have the one, Shreya Singhal has got it done because of us, and this has been repeated. Don't worry, next hearing we'll take it up. I said, sir, one day I'll have to file a contempt application. Are you forcing me to do that? So he said, no. So, I mean, coming back to it, now I have a problem, sir. These were all Facebook posts in 2012. At that time, what standards were being maintained, nobody knows, because I know for a fact that the person who filed a case against me, he's deleted all his blogs from Facebook. But unfortunately, we have links to it, but I don't know how much the links are going to help to recreate those blogs. And who's going to recreate the blogs? You see, so the fundamental question comes again is that how much faith do we have in the investigating officer? As somebody just said, artificial intelligence, yes. But the fact remains is, if artificial intelligence is programmed in such a manner to overlook certain data, then it is not going to be of any use. So we are going back to square one. And then I'll have to rely on basic evidentiary value of whatever is being taken. So, I mean, it's really nice. Today's program has brought in two good experts. They have told us in the direction in which we are going. But I kept saying that our laws or the lawmakers will not be able to keep pace with the way the cyber crimes are taking place. I mean, every day there's a new strategy. I mean, the criminals are much ahead of the law and the implementation of the law. So having said that, sir, it was very nice hearing you. Thank you very much. And Shyam sir, thank you once again.
Before that, before concluding, Mr. Bhadran and Nabeel, see, investigating officer is collecting it. Whether they are selecting the messages or selecting the topic that has to be analyzed by you, or they are taking the hard disk and sending entire hard disk is being sent to you.
The hard disk is
With the hard disk. Okay.
Huh? No, how far you will be able, because once the hard disk is sent, you may not be knowing which is the area where you will have to collect and analyze whether it has been tampered or it is original or how it has been done, etc.
So they only give you what they want to be, what they are relying on.
That is what I am asking about. See, when they are collecting the evidence, whether they are taking any copy of the portion of the document or a portion of the digital evidence that has been collected by them to be analyzed by you, or they are removing the hard disk and the entire hard disk is being sent.
Hard disk is sent.
Entire hard disk. So you may not. How can you know that which is the portion of the hard disk or messages or the document encrypted inside?
Along with the hard disk, they will send a requirement. These are things which we are looking at. Maybe a letter written on 12/6/1940,
etc. They will give.
So we search for that.
So, Ramashan sir, it is not, I mean, my understanding is that is not just like other countries wherein you go and come back with saying what a development, because you see only what they want you to see. The tourists will only be shown what they want you to see. So here these experts see everything and they will give an opinion, I believe.
No, on the basis of the request made.
That of course, because the offense might have been committed between such and such hours in such and such days. So they might require all the, evidence available.
No, probably they may say what are all the transactions happen in between, whether that has been entered in there in the digital media or not, etc. Probably that may be the.
Exactly.
Yes, sir. A wonderful evening indeed. A Saturday evening well spent. That too, even though it has links with the legal field, the interface of law and technology is always interesting and at times astonishing, because we speak a lot about it. We argue things without knowing. It is just like me switching on the light, and I know that if current is that, the light will glow. How it works, or what is the technology, or what is the basic science behind it, without understanding that, we have been dealing with this.
No, even if we can talk for another.
And for that matter, Nabeel and Bhadran sir, thank you very much. Sushanth, indeed indebted for that introductory remarks. And Justice Ramashan sir, thank you very much for your valuable presence and inputs, and all of you wonderful participants for this interactive session, wherein at least within this short span of time, we were able, or we were exposed to the different nuances. This is not an answer, or this is not the final statement, but this is something that will make us think about it, do something about it. And like Kevja Rao said, maybe the criminals are ahead, maybe the lawmakers, because we see they are sitting, criminals are sitting now in the lawmaking, seats. Not that I want to make an aspersion.
No comment, sir.
No, you get the government you deserve. You cannot, we cannot blame it. So, end of the day, let us all put in our constructive inputs instead of complaining and whining. What we can do as an individuals, what are things we can, do. All those things. Today's was an enlightening evening. Thank you all. Thank you very much. Till we meet again next week. Do take care, stay safe, and stay away from all these digital things. Thank you.
Thank you, sir. Thank you, sir.
Thank you very much, sir.
Thank you.
Thank you.